Good morning and welcome to Government House. I'd like to welcome you to a press conference this morning, and holding the press conference is going to be our Acting Attorney General Terri Griffiths and our Property and Procurement Commissioner nominee, Mr. Randolph Bennett. Thank you.
Good morning, government workers, people of the Virgin Islands, and the press. We have a number of issues to talk about today, so I'd ask that you hold all questions until the end. About 6 matters. The first one involves the Moffley security improvements to the former resident, or the residence of the former Governor John DeYoung. On behalf of the Department of Justice, I sent a letter to former Governor John DeYoung last night. I'll briefly read it into the public record. Dear Mr. DeYoung, the Commissioner nominee Randolph Bennett, Department of Property and Procurement, forwarded your manager's check of $202,831.60 to the Office of the Attorney General. The check was accompanied by a document signed by you as the obligor dated December 19, 2014, when you were serving as the Governor of the Virgin Islands, concerning certain security improvements to number, and I'll leave the address out of the public record. The document dated December 19, 2014 states that monies were used for driveway construction and paving, the erection of a perimeter fencing, the construction of a guardhouse, and the installation of security cameras. Second paragraph, the United States Inspector General issued a report dated January 2010 stating that the total misappropriated funds used for security improvements to your residence were $490,025. The primary concern was and continues to be that the funds were improperly redirected from public roadways to the security improvements of your personal residence. The document dated December 19, 2014 purports to represent that you have no legal obligation to return the misappropriated funds. Further, you attempt to justify a reduction in the total misappropriated funds based on a one-sided methodology claiming depreciation and demolition cost of the improvements. Your unilateral terms run afoul of the findings and opinion of the U.S. Inspector General's office and further does nothing to bring your misuse of government funds within the confines of the law. As pointed out in the January 2010 report, since the appropriated funds should never have been used to finance security improvements at the governor's private residence, all contracts and agreements issued for that purpose are invalid. Accordingly, the Department of Justice cannot excuse and/or compromise the total misappropriated funds that were redirected from the roadway funds to your Moffley residence. Moreover, the government of the Virgin Islands needs to fully assess the nature and consequences of your conduct and the resulting loss to the government to include any amounts of restitution that may be due as a result of your conduct. Accordingly, we simply cannot accept your unilateral representations of your asserted obligations to the government, and the government of the Virgin Islands hereby returns your $202,831.60 check. I ask him to direct any further discussions or communications regarding the check and/or the security improvements to me personally. With the assistance of Commissioner Designee Randolph Bennett, we recently obtained copies of the 3 appraisals of the security improvement from the Department of Property and Procurement. Then Commissioner Lynn Millen-Maduro requested 3 confidential appraisals of the security improvements in the fall of 2014. I will let Mr. Bennett respond to that.
Good morning. We did some research in our operation and uncovered 3 appraisals that were done by Shepard Barrows of John Foster Real Estate, Barrows, Elisa Runyon, and also from Mr. Jamron Corporation, with an average amount that equals $340,816.67, which is above the funding that was returned to our department. Thank you.
I think we've made copies of all three appraisals available to the press in their press packets. I also want to emphasize that the January 2010 U.S. Inspector General's report identified the cost of the security improvements at close to $500,000. And I'd also like to emphasize that nobody's taken the position that a governor of the U.S. Virgin Islands is not entitled to proper and adequate security. However, as emphasized by the U.S. Inspector General's report, we need to ensure that all funds redirected to the Department of Public Works by Act 6917 and improperly expended for security improvements at the governor's private residence be returned and used as intended. The next subject is Jonathan Cohen. In a criminal information filed by the government of the Virgin Islands with the District Court in St. Croix, U.S. Virgin Islands, Jonathan Cohen was charged with 21 counts of failure to file an income tax return. He's charged under Title 33, Section 1524 of the Virgin Islands Code. In addition to other penalties provided by law, which is penalties and interest, this section imposes fines of not more than $10,000 or imprisonment of not more than a year or both, together with the cost of prosecution. I noted a plea offer on the table for Cohen that dismissed all counts except for one. I was also concerned about the calculation of the tax arrearages. Essentially, under this plea offer, Mr. Cohen the government doesn't even object to expungement of any convictions. Attorney Counts, who was assigned to the case at the time, provided me with an email dated, I believe, the week of November 24th, from the former Attorney General, Vincent Fraser, authorizing her to tender this plea. I directed her to pull the plea off the table and assign the case to another attorney, Daniel Houston. Under both United States Supreme Court precedent and Third Circuit precedent, generally a prosecutor may withdraw a plea offer prior to a change of plea proceedings. Even after there's been a plea entered, there is case law for withdrawing a plea offer. In the Department of Justice on November 24th, 2014, in another case, a plea offer was tendered and accepted. That plea offer was also authorized by the former Attorney General, Vincent Fraser, and it had to do with a tax matter. It turned out the tax arrearage of $100,000 as reflected in the plea offer was not accurate. It was not accurately calculated. And furthermore, there was no allocation of the $100,000 tax arrearage to a tax year. So although we are working on that, as of today, that $100,000 check cannot be cashed, or it has not been cashed, due to mistakes. We can't afford those kind of mistakes. Frankly, I have a master's in tax law and would not deign to attempt to calculate tax arrearages with penalties and interest without the skill and the assistance of the BIR director. We owe that to the people of the Virgin Islands. The next topic is the status of the extradition proceedings of Mikhail Young. On May 12, 2015, a hearing was held in Sudbury, Massachusetts regarding the charges against 24-year-old Mikhail Young. Regarding the charges, for the murder of his adoptive parents, Kenneth Young, 73, and Jane Young, 66, who were found on Sunday, May 3rd, at a vacation resort here on St. Thomas. Mikhail Young has refused to waive extradition, providing for his return to stand trial in the U.S. Virgin Islands. Lieutenant Governor Potter, acting as the acting governor of the U.S. Virgin Islands, signed the governor's warrant yesterday for the extradition. It will be forwarded to the governor of Massachusetts, Charles Baker, forthwith. We have recently learned, however, that Mikhail Young has obtained a private lawyer representing him, and that the Massachusetts court has scheduled a hearing for June the 4th regarding Mikhail Young's competency to stand trial. This may slow down the extradition process. So even though the papers are ready to be forwarded, there's no guarantee that extradition will be forthwith. The next three instances all deal with fugitive warrants. We have an obligation to the citizens of both the U.S. Virgin Islands and citizens in the U.S. mainland to actively and aggressively pursue our fugitive warrants through the extradition process. The first one is fugitive Peter Dwayne Watkins. On May 16, 2015, 40-year-old Peter Dwayne Watkins entered the USVI on a private vessel. He came from the BVI and went through customs in St. John. He was detained on a fugitive warrant from Pitkin County, Colorado, that's Aspen, for felony sexual assault. He is being detained pending extradition. The next fugitive apprehended recently is Javon DeParle. We received notification from Orlando, Florida, Orange County Sheriff's Department that Javon DeParle has been recently arrested on the USVI fugitive warrant for murder and firearms-related charges in connection with the shooting death, and that happened in 2013, of 37-year-old Andy J. Peters. He died after he was shot multiple times in the Lorraine Village Apartments in Estate Grove Place. DeParle has waived extradition rights, and he will be extradited back to the Virgin Islands on or before June 3rd, 2015 to stand trial. The next fugitive apprehended was last night. Rashawn Francis was apprehended at the Cyril E. King Airport. The VI Port Authority PD assisted Customs and Border Patrol in the arrest of Rashawn Francis. He is from St. Thomas. However, he was arrested on a fugitive warrant issued by Orange County Sheriff's Department, that's Orlando, Florida, for narcotics and resisting arrest charges. We have detained him pending extradition to Orlando, Florida. We would like to take this time as the Department of Justice to thank everyone in the law enforcement communities. There is a team of cooperation, teamwork, diligence in both apprehending fugitives, finding them, and extraditing them. So the federal law enforcement community, VIPD, Orange County and Orlando, Florida, Sudbury, Massachusetts, all of these law enforcement teams deserve our thanks and appreciation. We'll take questions related to the incidents that we discussed, both Commissioner Bennett and I this morning.
I'm Jonathan Austin with the Daily News.
Good morning.
Go ahead.
Thank you.
Given the current news regarding the former governor, would you be willing to discuss any possible criminal investigation?
Sorry. That situation is under investigation, not subject to discussion at this point. Anytime there's an investigation pending, it's off the table for discussion. However, we have a press handout for you, a lot of documents, and I can tell you it's under investigation. That's all I can do is confirm that.
Very good. May I ask a question of the designee? Sir, you're assisting in the pursuit of the former governor for performing tasks and construction at his home that was not outlined in the law. But currently you're, by your own admission, seeking to provide housing for the lieutenant governor. Can you tell us where in the law your efforts that you're pursuing fall for that action?
We've stated earlier that we're addressing questions on the subject that the 6 areas that we discussed. That is not an area that is up for discussion at this time.
Okay, that's all for now.
Okay, may I emphasize, as I did earlier when I spoke, we're emphasizing, just like the U.S. Inspector General did, that the funds were diverted from public roadways and through misappropriation and spent on security improvements without proper authority.
Jonathan Austin again. For the designee, in conversations you and I have had through email, you've said you had no documents regarding appraisals from Affley. Did the former governor offer you any written reports or appraisals that you have on file?
No.
So the appraisals we have, as you mentioned, were performed at the government's request and expense.
Yes.
Thank you.
Good morning. I'm April Knight from TV2.
Good morning.
Former Governor John DeYoung opted to live, according to him, in his own residence and beefed up security there because, according to him, it will be much more expensive to move his family to Catherineburg. Now, Governor Mapp is also now not living in Catherineburg and instead renting separate residences for himself, also incurring costs that the money for which should also be coming from somewhere. What is the difference, since both of them are incurring costs as a result of not opting to live in Catherineburg? How is one okay or legal and the other not?
Well, like the Inspector General from the United States said, the issue is funds were diverted for those security improvements from an account that's been allocated or that had been allocated for public roads. So there was no proper allocation to those security improvements.
Did the government of the Virgin Islands conduct any investigation alongside of or before the U.S. federal authorities engaged in their IG investigation?
As I was not the Attorney General at the time or acting Attorney General, there's nothing in the files to indicate such. But I'm not going to stand here today and tell you it wasn't done.
Morning. My name is Judy Schimmel. I'm a reporter for the St. Croix Avis. Attorney Griffith, can you tell us why Assistant Attorney General Denise George Counts has been suspended indefinitely from her post, and did it have anything to do with her conduct in prosecuting the Jonathan Cohen case?
As I reflected in the notice filed with the federal court in St. Croix, we withdrew that plea offer. Denise George Counts, Attorney Counts, was directed on or about April 27th, actually before that, to pull the plea offer off the table. She did not do so. The plea offer, the last plea offer, was dated, I believe, April 9th. She had no authorization to tender it except for Attorney Frazier's email dated November 24th, 2014. In fact, as acting Attorney General, I knew nothing about it. Nevertheless, she did not pull the plea offer off the table. However, it expired on April 27th. And like I said, the case had been reassigned to Dan Houston for basically an audit and to get with the BIR to see if the tax calculations were actually correct. Daniel Houston is not admitted into the District Court of the U.S. Virgin Islands. It's a fairly new procedure that you have to be formally admitted into the District Court. He was doing his paperwork and could not get his paperwork together in time for the hearing a week ago Tuesday. So Attorney Counts was directed to appear at the suppression hearing. She had no authorization to enter into the plea offer dated April 9th, which had expired, and she did so on May 12th. She's not suspended indefinitely. We're trying very hard to give her a status tomorrow, but we're still reviewing the file. And we can't really discuss it anymore because we have a hearing. Let's see, we have a hearing tomorrow in federal court.
Thank you very much. And if you need any information, you have a full array of documents backing up what was presented today in the press kit. If you need anything else, please feel free to contact me. Thank you.